Good morning, and thank you for joining us. My name is Vince Bizdek. I'm the executive editor of the Gazette newspapers, which include the Denver Gazette and Colorado Politics. Welcome to Colorado Conversations, where we explore and flesh out the biggest challenges facing our state and the policy proposals aimed at fixing them. We have a big topic this morning, construction defects, and we have a great panel today. Before I hand it over to Luigi Del Porto, who is moderating this morning's discussion, I want to take a moment to thank you for tuning in. I encourage you to ask questions using the chat or the Q&A function of Zoom. I also implore you to explore the journalism that we produce at Colorado Politics and the Denver Gazette by visiting coloradopolitics.com and denvergazette.com. We hope this morning's conversation is illuminating. Over to you, Luigi.
Thank you, Vince. As you know, Colorado developers have pointed out or have pointed to the cost of liability for dealing with construction defects as one of the biggest barriers to building condos. Others, however, maintain no correlation exists between construction defects, litigation, and the lack of affordable housing in our state. Of course, at the state capitol, lawmakers have introduced legislation they hope would kickstart a new construction of affordable condo units. As Vince noted, we have a great panel this morning. Joining us, she'll be a little bit late, but she'll be here, is Senator Rachel Zenzinger, who is a state legislator from Arvada, who represents Senate District 19, which is based in Jefferson County. She's a licensed social studies teacher at the secondary level, and she also serves as vice chair of the Joint Budget Committee. Again, she'll be joining us here in a little bit. Also joining us this morning is Peter Lifari, who is the CEO of Maker Housing Partners, a public housing authority operator and developer of multi-family affordable housing based in Adams County. Peter is also a fellow with the Common Sense Institute. Peter, thank you for joining us. Also joining us this morning is Jeff Niels, an economist and full-time associate with Pacey Economic. He authors reports and provides deposition and trial testimony relating to litigation and personal injury, death, employment separation and termination, as well as business dispute cases that use various labor economics data and research. Jeff also deals with public policy. Jeff, thank you for joining us.
Thank you.
Also joining us this morning is Scott Wilkinson, who is a legal advocate with the Homeownership Opportunity Alliance, one of the groups that is backing one of the legislation that we'll be talking about this morning. Scott specializes in insurance disputes, securities fraud, construction defect, and employment matters. Scott, thank you for joining us.
Happy to be here.
Also joining us this morning is Jen Seidman, who is a legal advocate with Build Our Homes Right. In her private practice, she represents homeowners and homeowner associations in construction defect and defective building products cases. Her works includes cases involving structural failures and foundation movement, water intrusion, and building envelope failures. She specializes in litigation involving building product defects and design professional errors. Jen, thank you for joining us this morning.
Thank you for having me.
Okay, so as Vince noted, we have a big subject this morning. I'm actually going to start with Scott. Scott, you mentioned just before we began this program that you deal with a lot of this construction defects litigation on the back end of things. Very briefly, tell us, what the current laws are, and from your point of view, what the potential problems, or I shouldn't say potential, what the problems are that you're seeing from your end.
Yes, so the nice thing about what we do is our firm represents builder developers both at the beginning of construction stage and in this dealing with construction defect actions. And so I see both the planning aspects as well as the aftermath of the defect litigation. I think the biggest issue that we're having here in Colorado is frankly the proliferation of the litigation and the breadth of what is being asserted. So for us, and I'll use an example of a case that I'm dealing with right now as coverage counsel. We're seeing too many cases that are being brought with respect to what I would call otherwise performing buildings. So we call those technical violations that have no impact on how the building actually works. The one that I'm dealing with right now, there's an allegation that basically there aren't enough nails in the OSB attachment on the sides and top of the house. because there's a code provision that says you have to have every so often nails or attachments. And there were sporadic instances, not systematic, but sporadic instances where those nails weren't close enough together. So in that suit, they're alleging that we need to take off the entire roof, all the shingles, reaffix the OSB, redo the roof, take off all the siding, reaffix the OSB, redo all the siding, take off all the masonry, reaffix the OSB, redo this masonry. So the bulk of the damages in that case is things that, frankly, if the case settles, they're never going to do. And it has no impact on the performance of the house. But that's the kind of things we're seeing that crop up. And those are in addition. I'm not saying that all defect cases aren't, are that way, but we're seeing these defect cases that are brought that are padded, and it's having a horrible impact on the insurance industry. Over the last 15 years, we cannot get any more traditional CGL insurance for multifamily projects. It's only available through a wrap process and at many multiples of what the cost was 15 years ago. And that's defect related because the insurance companies have been paying out exorbitant amounts of money, and many of them have withdrawn from the market because they can't stay in business here. So what we're seeing in Colorado is a climate that encourages that kind of litigation and discourages the most affordable housing product that you can put out there, which is a dense condo product, because most of our builders that we represented, if you ask them how many projects they haven't been sued on that they've built, they'd say none. And that's a problem.
Thank you, Scott. Let me bring in Jen, because Jen, you're in the front lines of litigation as well. First, I guess the same question to you. What are you seeing on that end? But also, I do want you to comment on what Scott just offered.
Sure. So by the time I get involved or my firm gets involved, the problems that homeowners are experiencing are pretty serious. If they're experiencing minor problems, or if they can get the builder to fix them, they're not going to call a lawyer. The first thing a homeowner does when they see something leaking or something not working right, they don't call a lawyer, they call the builder, they try and get it fixed. Just like if a person has a medical problem, the first person they're going to call isn't a lawyer, they're going to try and get themselves treated properly. By the time it gets to us, we're seeing very serious problems: cracking foundation, leaking windows, mold, defective shear walls, which is the part of a structure designed to withstand heavy winds, defective fire safety systems. When a homeowner brings a lawsuit, usually that process takes a few years. Part of that reason is Colorado has some of the most builder-friendly laws in the country, and homeowners have to go through months and months of pre-suit attempts to try and resolve the problems without litigation. They have to provide notice to the builder. There has to be, there can be a back and forth to try and resolve it. They can't actually file suit until they've gone through this lengthy process to try and resolve things informally. So by the time I'm involved and we're in court or in arbitration, the builder hasn't stepped up. The problems are serious. There's no realistic alternative other than trying to get it fixed through the courts or through arbitration. In terms of what I heard about, I think I'd call them frivolous claims. There are so many safeguards in Colorado law presently to prevent that. Sanctions for bringing frivolous claims. In 2017, we heard a lot of the same concerns that are being raised now. There's a desperate need for affordable housing, and it's not being constructed because insurance costs are so high. Extensive reforms were passed in 2017. What we were told from the industry at that time was that these reforms would lead to lower insurance rates. They would lead to more affordable housing. That didn't happen. The reason that, at least that I heard, that outcome wasn't expected was because of this belief in these frivolous claims and these claims based on technical violations. But that's not what homeowners are pursuing. They're pursuing real problems, and they need real help. And these additional, I'll call them obstacles to getting to court, to getting relief, didn't have an impact on insurance rates, didn't have an impact on affordable housing, because they're not a lot of frivolous claims to prevent. That's already prevented under Colorado. So, you know, one of the things with the current efforts and in the same narrative, you know, if the issue, if the goal is quality, affordable housing, then it seems that the solution would be efforts at the outset to make sure that things are built right, to make sure that inspections are being done properly so that mistakes don't happen. And if mistakes don't happen, there's no defect claim. And this is all a non-issue. You know, unfortunately, the bill, Senate Bill 106, touts that as a goal, but there's nothing in it that tries to promote the quality of housing. It's just trying to reduce lawsuits, including very valid claims. And I'm sure we'll get into some of the details later.
Thank you, Jen. Let me bring in Senator Zenzinger. You are the prime sponsor of this construction defect bill that I think is already out of committee, correct? Senator, can you really briefly tell the audience what this bill seeks to do, and in a broad way, how it would fix the overarching goals that we have, including encouraging the construction of more condo development?
So the bill really seeks to do three things, and the bill did just pass out of the Local Government and Housing Committee, so it is heading to the full Senate for debate, probably sometime next week. And the three things that the bill seeks to do is, number one, to create a pathway that is separate from court, that would be optional for folks to choose if they so desire, that would allow a robust process to be able to fix the problems that occur, but without taking those to court, which is the most expensive option. It doesn't prevent anybody from still going to court if they would like to. But we have right now in current statute a process by which you can have a claim for a defect. And the process right now, as it is outlined in statute, is not really being utilized. I don't believe that it has the proper safeguards for all parties, the construction professional or the homeowner. And so it's just not being taken up with any seriousness. Right now, the construction professional can agree to fix it, or the construction professional and the homeowner can agree to settle. We are amending that process by adding into the mix another option, which would be for the homeowner to choose a third party to fix the construction defect, and that would be at the construction professional's cost. And so we are trying to make that right to remedy a better process for all involved, so that we can try and settle or address these construction defect claims without choosing the most expensive option. Again, it's just another pathway. It is not required, and it wouldn't force anybody into it. Both parties would have to agree that they want to go down this road. So that's the first thing that the bill aims to address. It wouldn't necessarily make a huge difference on the affordability issues if people choose not to use it, but we do feel like having some proper guardrails and outlining the process more clearly would make it a better option, and maybe we could start to address our problems down that road versus heading to court right away. So that's the first thing. Secondly, there's a part of the bill that really addresses on as you heard from Jennifer, some laws that we already passed in 2017 around disclosures. And we have heard from the field that that disclosure process is not really being utilized. It's being ignored, and it's not those disclosures are not really happening. So we're trying to heighten the transparency process that is already in law. And then also we're trying to make all the homeowners in a home ownership association, an HOA, better understand the consequences of taking a claim to court. So that's the second thing. And then the third thing is addressing negligence per se, which is the issue that you just heard from Scott about a little bit, which is trying to parse out technical violations versus violations where there are impediments to the functioning of the home, or where there were damages, or where someone was harmed. All of those three instances, you would already have a claim, and we are not trying to parse those out because we feel like if you want to seek remedy through court for those, you should, or choose our right to remedy. But why are we continuing to go to court on technical violations? More likely, what is happening is that there is a claim where there is damage, and then these technical violations are stacked on top of it in order to increase the size of the claim, or to, and the problem with that is if you increase the size of the claim or the number of claimants, that's what drives up cost. So those are the three things that our bill seeks to do in order to try and address these problems outside of a courtroom. We feel like if we're able to make the homeowner whole, if we're able to address the problem, if we're able to do it in a speedier way than going to court, because the process of going to court is sometimes very lengthy, we feel like everybody would be served by that. I do want to point out that that right to remedy is optional. Some people felt that prior to committee and prior to an amendment that we brought forward, that it was forcing people into this pathway, and we're not. It has to be agreed upon by both parties. But people aren't going to choose that pathway if we don't put the proper guardrails around that process, which is what the bill seeks to do.
Thank you, Senator. Jeff, I want to bring you in. You know, you've heard Scott, you've heard Jen, and of course you've heard the state senator. First, I want to get your take on the bill. And then just broadly speaking, what problem are you seeing and what solution do you have in mind?
Yeah, so I think we all want the same thing. We all want affordable housing. And we want affordable housing, excuse me, that's built correctly. And my view from studying this from more of an economics perspective is that this bill will not solve the problem that it wants to solve. And just quickly, coming out of the Great Recession, we had lower interest rates. It's harder to get a mortgage, and we had an increase in investing in the housing market by big, large scale investors. And so what happened is a large shift from builders building for sale units about half the time to now predominantly building for rent units. And the cause of this shift is very well documented in the literature, and it has nothing to do with construction defect laws. So I think it's not right to think that changing construction defect laws and making these little tweaks will change this reality that these builders who are building a lot in Colorado and are making a lot of profits are going to all of a sudden switch to building for sale units instead of these for rent units. And I just want a quick analogy that I want to bring in is, well, first, we're always taught in economics, the law of supply and the law of demand, that if we can find a way to decrease the price on something, so the insurance price or the price that will increase the quantity. But there's a problem with that, and that's if you have a substitute good, that won't always be the case. So if you have a gas station selling gas for $3 a gallon, and then across the street one selling it for $2 a gallon, everybody's going to buy the $2 a gallon. So then let's say you find a way to decrease the price of the $3 a gallon gas station down to $2.75 or $2.50. Well, you've decreased the price, so that should increase the quantity demanded, right? Well, in this case, it won't, because everyone's still going to buy gas from the $2 a gallon gas station. So my whole view on this is that this law passing will not create more affordable housing. Builders will still be building these for rent, profitable for rent complexes.
Thank you.
Luigi, do you mind if
Just
I've
really
been
quickly,
listening. Can I,
yes, yeah, go ahead,
can I
sir.
jump
I'll
in?
go to Peter, yeah.
So we represent a bunch of builders, and I also pay a pretty good attention to, and when I say residential builders, and I've read Jeff's paper, and the thing that I really have a hard time with is, let's take a Lennar Communities, right? Lennar is the biggest home builder, commercial home builder in Colorado, and one of the biggest in the nation. Lennar is building stacked condominium units for sale in other states. They won't do it here. Why? Okay. Same thing for other builders whose business is building for sale homes. Now, Jeff relies on the apartment construction component of it because it's happening. Apartment construction is happening because there's a demand for housing. And people are filling that space that are not traditional for sale home builders. The traditional for sale home builders still build multifamily in other states. They won't do it here. And it's universally accepted among all of my clients. I struggle with Jeff's paper because I have this conversation with national builders on an annual or biannual basis where they say, hey, can we come back to Colorado? And we say, these remain your risks. And those risks haven't changed substantially over the last 10 years. I really struggled also with Jen's characterization of the defect laws here in Colorado as for most friendly in the nation. We have no right to repair as builders. So if there's a problem in a home and a homeowner won't let us fix it and they want to sue us, we can't go in and fix it. We can't, do our job unless they let us. So there's no right to do that. And there's also effectively for a general contractor or a home builder, they are de facto responsible for everything that everybody else does underneath of them. So they have to, they're sued, and they have to seek to then allocate responsibility down chain. There's no, hey, the subcontractor X screwed up, then subcontractor X has to bear the brunt of that. No, the developer, the builder, the general contractor, who's the one that's going to be bringing the condo project, we hope, into the state, is the one that bears the brunt of that lawsuit, and then they have to spend the additional money to chase it. So characterizing that as the most friendly in the nation, I think everybody on this side of the table would strongly disagree with. The last thing, I found it interesting that when I brought up the example of the OSB attachment issue, which is a claim that it is allowed under the current law, Jen mentioned frivolous claims. Well, I agree that that's a frivolous claim. If there is something that is a performing building and you have, just this kind of, technical violation that does nothing to the performance, that's what we're trying to get out of the law. And that's what Senator Zenzinger mentioned. That's what we're trying to do with Senate Bill 106 is say, if you have a technical code violation that doesn't impact the performance of the building, it's not going to be a grounds for a lawsuit. And we're getting some staunch resistance from, among other things, the trial bar, because they want to continue to have that in the lawsuits. And therein lies the issue. The only way you're going to fix the insurance problem is reduce the frequency and severity of lawsuits. Okay, that's it. And the best ways to do that are either allow people to fix it up front or take what I would call the fat out of the lawsuits. Make the lawsuits about the real issues and not about the stuff that's never going to get fixed. Sorry,
Thank you,
I
Scott. And
kinda
I
had
will
to-
give, thank you, Scott. I will give Jeff and Jen a chance to reply to that. But really quickly, I just want to bring in Peter. Peter, you're a developer, and you've encountered many of the issues that we're talking about here. But from your point of view, what is the issue? What's the problem? Why are you not building condos, or not? I mean, not you personally.
Mm-hmm. Yeah, no, thanks. It's great to be with everyone. Since 2021, as you mentioned, I'm an affordable housing developer. My passion is to serve Coloradans that the market won't because of their income status. And so I build rental product. I believe in rental product, but I also know that without a healthy housing continuum of all different types, both affordable, market, for sale, ownership, we are going to be where we are today in a world of trauma and pain, where Coloradans cannot find an affordable housing type that suits their need, be it rental or for sale. And so, back in 2021, when the Institute asked me to become a fellow, we started digging into the housing unit shortfall. and the main drivers. And I've written on a number of elements. And so, when we looked at where have all the starter homes gone, we started to look at the traditional starter home, which is a condo. And at the end of the day, we started to see, oh my goodness, from 2002 to 2008, we were averaging over 3,000 condo starts per year. From 2018 to the point of my report last year in September, we were averaging 574 condo starts. So then we said, okay, let's peel the onion back here and start to look at, where have all the developers gone? And what we found was that there were 146 unique developers operating in the Front Range, developing for sale condos. Their primary source of business. They were not, developing rentals, right? They were developing townhomes and condos. And so, we said, okay, well, what about in 2023? Well, only 23 remained. And I think Local Homes is a great example of this. Local Homes is one of the last brave developer souls in the Front Range taking on this incremental risk. They're still building condos this year. They're not going to build condos next year. And when you ask their president, why are you exiting the space for which you exist to operate in, right? They're not producing rentals. They say, we just can't secure insurance anymore. So we said, okay, let's take a look and see if we can't peel back the onion and find out the cost spreads that are directly correlated with the actuary risk, as Scott had shared. And what we found is it's about 1.1% of hard costs, half of hard costs, to insure a single family product for sale. It's about 3.5% of hard costs for a townhome product. It's 5.5% of hard costs for a condo product. And that is directly correlated back to what Scott had mentioned, was the frequency and the scope and the impact of the fiduciary penalties that are being assigned based off of the frequency of litigation, right? So we said, okay, that's interesting. How's that impacting the mix of what's being developed? And if we go back to that 2002 to 2008 timeframe, we had greater parity and we had a healthier housing continuum because of it. And what that was we had, for every one condo developed, we had 1.25 apartments developed. Well, if you fast forward again, from that same time period from 2012 to the present, we've got one condo built for every 14 apartment units. So, yes, when you talk to developers that have exited this space like Lennar, right? And yes, Lennar is a profitable company. We want them to be profitable so that they can cover their costs of operations and deliver our most foundational need. But those profits that were cited by my friend Jeff are for the entire nation. And they don't discern as to which product type or what has been delivered here or what percentage of those product types were townhomes. And so, for me, we have to figure out a way to reintroduce the most affordable and attainable ownership products, because we can't just continue to devour greenfields in our state and consume our precious agriculture and open space lands. We have to build up. The future of housing is up. And if the future of housing is only rental product, we are excluding generations from pursuit of happiness and the ability to accomplish the American dream. And so we have to figure this thing out, Luis. And I think that the bill goes a long way in accomplishing that. There are other elements that I recommend in my report that the bill does not contemplate. I hope to see those in future years. One is, as an example, we need to harness our middle income housing authority, of which I'm on the board, so that we can re-enter the space, take on more risk as a governmental entity, be able to produce homes that we then sell, which, by the way, addresses our greatest failure coming out of public housing, which was we didn't sell public housing units to the Americans that inhabited them, and we have generational poverty as a result. And so if we can move back in, there are multiple things we can do. This is a multi-pronged approach, but the Senate Bill 106 goes a long way to helping us address the issues in the marketplace today.
Thanks, Peter. And really just quickly, I'm an immigrant to the United States and I grew up in the Philippines. And so the idea of the American dream is ingrained in me growing up, because I see that in movies. I read that, used to read that in the books a whole lot. And, I went to an apartment when we were starting out, back in 2006, 2007. We do now own a home. And there's value and there's pride to home ownership. It is a unique property that hopefully we would be able to pass down to our son. And so there's a lot of that. There's pride in ownership, and I do think, just personally, I'm not supposed to give you my opinion because I'm a journalist, but I do think that home ownership, whatever the home type is great. In that continuum that you talk about, Peter. Jeff, go ahead and answer Scott's points.
Yeah, so just generally, I've been hearing quite a bit of anecdotal references to conversations with Lennar, conversations with insurance companies, conversations about what's going on in other states. But I'm a data analyst person. I want data, and I dug into the data that's looking at what's happening at a national level and what's happening in other states and cities that are similar to Denver, like Salt Lake and Austin, Seattle. And this problem is happening all across the country. And Peter talked a lot about the pre-recession versus the post-recession, how many were being built. But what's clear to me is that the cause has nothing to do with construction defect litigation. The causes were the shifts I mentioned earlier: lower interest rates, harder to get a mortgage, and tons of institutional investing. And they all want to build for rent products. So that's my response to what I heard from Scott and from Peter. And just quickly, I agree with Peter that another way to get at this, and I think a much better way, is through the housing authorities that you mentioned. They're usually at the municipal level, at the city level, and these housing authorities can and do already require builders to build for sale affordable units. And that's directly solving the problem we're trying to solve, rather than hoping that will solve some problem by tweaking construction defect laws.
Thank you. I'm going to bring in Senator Zinzinger in a little bit, but Jen, go ahead, because Scott, and correct me if I'm putting words in your mouth, Scott, but you're saying that there's a ton of frivolous lawsuits that's happening. You're dealing with one right now. Jen, you said earlier that you don't really see this frivolous lawsuits. That at the end of that process, when the homeowner doesn't have a whole lot of option because the defects are structural, they're not technical.
So Luigi, I just want to be clear. It's not a situation where we're saying an entire lawsuit's frivolous, right? And there's a definition of frivolous under the law, which means baseless. And part of the problem right now is these technical code violations are permitted under the law.
Got it.
So that's what I'm seeing in my practice is I'm seeing litigation that has some legitimate defects, but then grows sometimes exponentially in cost and size because of the tack on of some of these, what I would call technical code violations. And it's the things that, even if they win, probably aren't getting fixed. That's what I'm seeing. And that's what I'm suggesting we could trim out of the process, because if we could limit it to the defects that really need to be fixed, then that would lower the actuarial basis. That's what I'm trying to say.
Thank you. Go ahead.
And so, for example, all of the claims are being treated the same. So the same claim that where there was severe damage or mold or crumbling foundations, those are treated the same as a flashing that was slightly askew, where there was no damage. It wasn't impacting the functioning of the roof or the building. In fact, you probably wouldn't even know it was there. Those are all treated the same right now. And what we're trying to do is parse out those serious claims that need to be remedied, where obviously, if you don't want to choose a right to remedy and you want to go to court, you should. But we don't feel that all claims should be treated the same, because a technical code violation is not necessarily negligence. It's a technical code violation that is not harming anything, that is not impacting the functionality of that building. So if we can parse those out, we think that will help drive down cost. If we're going to treat every claim the same, then it's going to continue to increase costs. And quite frankly, I think that hurts people who really have a defect that need it addressed, you know, that need to take that to court. If we're just piling on in order to increase those claims. So that's the goal. That's the intent. It's not to try and convince people not to file a claim because there are defects that happen, and when they happen, we want them to get addressed and fixed.
Thank you. Jen.
Thank you. I wanted to respond to primarily two things. One, sort of the general description of where Colorado falls in the national spectrum of defect laws, and then also the focus on claims based on technical violations. In terms of the broader picture, Scott brought up one example where Colorado doesn't go as far as some other states do in terms of allowing homeowners to decide whether or not to accept or reject a repair that's not going to fix the problem. There are very few states that do allow builders to come in over a homeowner's objection to perform repairs that are inadequate and insufficient and may cause additional damage. The bill was originally proposed in a way that would allow that, but has since been amended to allow owners to reject unreasonable repairs. From my perspective, that's not, I guess, an example of being lax. That's reasonable. That's good policy. Somebody shouldn't have their property altered over their objection in ways that don't make sense. But in terms of other laws in Colorado, we have some of the shortest timeframes in the country for bringing defect claims. There are problems, I mean, especially with expansive soils. It takes time for expansive soils to swell, cause damage, initial cracking, then serious foundation damage. If a homeowner doesn't bring a claim within the first 6 years, and occasionally it's extended to 8, but typically it's 6, they're barred. They're the ones who have to pay to fix the foundation damage if it happens after 6 years. They have 2 years from the date they noticed the manifestation of a defect. That means they don't need to know what causes it. They don't need to know who's responsible. That's probably the single most common reason why I end up telling people that we can't help them. Because they noticed, the very, very first instance of a problem more than 2 years ago, and Colorado law bars their claim. Many other states require that cause be determined as well. Homeowners can't get prejudgment interest here. This is the only area of law where consumers can't recover prejudgment interest.
Well, sorry, what is prejudgment interest?
So there's a repair cost estimate. Those are the damages. And in other cases, I feel like there's a lot of analogies to the medical context. So, the cost for somebody's treatment, in other areas of law, interest starts to run on the cost, on that number from an earlier date. Sometimes it's the date the claim is filed. Sometimes it's the date the injury occurs. But regardless, there's interest accruing. And so there's an incentive because of that for the defendant to settle, or to at least try and work things out, to explore settlement. Because there's no interest accruing on the claim, but they can invest the money and earn interest, it's in their interest to drag it out for as long as they possibly can. There's no disincentive. They actually make more money by making it take longer. And there used to be prejudgment interest on construction defect claims that was eliminated around 2010. And what we've seen in our cases is they all last longer. Settlement rates have dropped. That's had a devastating impact on homeowners. Those are some of the biggest, I think, different. In other states, homeowners can recover attorney's fees. Here, most of the time they can't. All right, so that's sort of big picture. In terms of this technical negligence per se code violation issue, current Colorado statute, and for those who like to actually look at the language, it's CRS 13-2804. It provides that no negligence claim may be brought based on a violation of a code or industry standard, and this, again, current law, unless that defect causes actual property, actual damage, actual loss of use, a risk of bodily injury or death, or or a threat to occupants' life, health, or safety. So currently, homeowners have to establish one of these harms in order to assert a claim based on a particular defect. What the bill does is, with the property damage exception, it requires that the property damage occur only as a result of certain code violations. So if the builder violates industry standards, if the builder violates the manufacturer's instructions and voids the warranty as a result, so that the homeowner can't use the warranty, There is no defect claim, even if there is property damage under the bill. That's the change the bill makes to that portion. In terms of the section that currently makes an exception for defects that create a risk of bodily injury or threat to occupants' life, health, or safety, the bill adds if the threat or the risk has to be imminent and unreasonable. Under Colorado law, the way courts interpret the word imminent is happening immediately. So, you know, under current law, if there's a defective fire safety system, the homeowner doesn't have to wait for a fire to be imminent. The homeowner can bring a claim to get the defective fire safety system fixed. You know, if there's structural, if there are serious foundation defects that are going to cause structural damage, and threaten the stability of the home, the homeowner doesn't have to wait till the crumbling is imminent. They can bring a claim based on it. So what I'm hearing is the intent of the bill is already reflected in current law. The changes that are being proposed in the bill are going to make this devastating for homeowners. And I mean, it's important to keep the focus on the people who are affected here. I mean, especially in the affordable housing context, these are people that cannot afford to fix foundation damage and rebuild their foundations if they fall apart, but the problem isn't imminent. These changes are really gonna hurt homeowners.
Luigi, I can't let that go.
Just really quickly, Scott, go ahead.
The reference to 132804, that statute might as well not be on the books right now, because the trial bar brings the technical code violation claims as breach of warranty or breach of contract claims, which are not subject to the statute. And so I've heard this, it's already covered in existing law argument multiple times, and we're trying to close that loophole so that that statement is actually true. And the trial bar is resisting teeth and nail our efforts to close that loophole so that the statement Jen made would actually be true. The other issue is we've tried to rectify, this is not a situation where the people pushing this bill are trying to cause harm upon homeowners. We heard the complaints about the imminent and unreasonable language, and we offered an amendment to define that as imminent and unreasonable means that there is an existing non-performance of the building that is causing potential risk, or that there's a component of the building, the fire protection system, to use Jen's example, that won't work when it's supposed to. Again, the trial bar opposed that amendment. So this argument about, trying to do harm, that's not what we're trying to do here. We're trying to take the fat out of the cases, which is what Jen says the current law does, but it doesn't. It's not effective. We're simply trying to make the current law effective.
Thank you, Scott. I'm sorry, Jen, go ahead. Go ahead really quickly, ma'am.
So as first, what I was responding to was the negligence per se issue. In terms of this effort to expand that section to contract claims, that's another serious problem. If a homeowner contracts with the builder to have granite countertops or a certain product or energy efficient windows or any certain quality product, and there's a bait and switch and a lower quality product is installed and it doesn't cause property damage, it doesn't cause loss of use, it's not causing a threat or a risk, but the homeowners paid for this other product and they didn't get it, that is included in defect claims, because
those aren't code claims.
That's a deviation from what's required. That absolutely is involved in
those aren't code claims. That you're talking about finishes. Those aren't code
violations of the plans and specifications, and the code requires compliance with the plans and specifications.
They're not code claims. You're not going to find granite versus energy efficient, or you're not going to find finish requirements in any adopted code.
Are you saying that the code doesn't require compliance with the plans and specifications?
Plans and specifications in what regard? You're talking about
what
finishes.
The plans require and what they specify.
You're talking about finishes, Jen.
So, okay. Thank you, Scott and Jen.
The window quality. I mean, there's lots of other examples. Anytime a product is required by the plans and a lower quality product is used instead, that violates the plans if it is required by the plans. The code requires compliance with the plans. A violation of the plans is therefore a code violation.
And I think this is a fantastic example of the kind of argument that gets made in defect cases, right? You have a granite versus whatever argument, and we're characterizing it as a construction defect and a code violation. No, if you didn't get what you contracted, that's a contract violation. It's not a code violation.
But the
Senator
intent is to
Zinzinger.
broaden this provision to contract claims. So the idea is to preclude those claims. They are not currently precluded. You're right. But the bill.
The idea is to not allow claims based on breach of building code, breach of manufacturer instruction, or industry standards. You're talking about a contracted finish standard. It's not subject to the statute.
Okay.
So it's a straw man argument that doesn't touch what the bill's intended to do.
Just to
Scott and
clarify,
Jen,
it's
really quickly, hold on, guys.
position that the code doesn't require compliance with the plans and specifications.
Scott and Jen, really quickly, I want to bring in Senator Zinzinger. Ma'am, you've been like, you've been signaling and trying to interject here.
Yeah, I just have to go, and I just wanted to say thank you so much for the opportunity to be here and to be a part of this discussion. I just wanted to leave you with a couple of thoughts from the perspective of the sponsor. So I do not believe that our bill is going to solve all of the problems. And that was never a claim that I think was made in 2017. And I'm definitely not making that claim now. What we are trying to do is trying to reduce the scope and frequency of claims that go to court, not to reduce the opportunity for homeowners to be able to get their defects fixed. We're trying to add another option into the mix with the right to remedy, which is to say, maybe we can fix this outside of court and in a way that would make the homeowner get their defect fixed in a timely manner according to the agreement that the construction professional and the homeowner enter into. And that agreement is optional, and we are really just trying to add another workable option into the mix. There are two other aspects of the bill that we have been debating. I get a little frustrated because it seems like we like to talk about things that are not in the bill versus what is in the bill. So the conversation around the negligence per se, I really appreciated because that is in the bill. And so I like the opportunity to be able to dig into that aspect of the bill a little bit more. I think that what we have put together is 3 solutions that would work together in order to reduce the number of claims that are going into court so that we can reduce costs. If you don't think that the insurance cost is a problem, then this bill does no harm. Then we're just adding some more opportunity into the mix. But if you do think that the insurance cost is a problem, we are hopeful that this will move the needle in the direction of trying to bring those costs down. For me, I just keep trying to go back to the why. Why am I doing this? And I'm doing this because in my community, housing is not affordable. My children are in college right now, and I really worry about my children not being able to come back and live in the community where they were raised. And by come back to my community and live, I don't mean in my basement. I want them to be able to have an opportunity to become homeowners, and a condominium is their best shot at that. You know, both of my children are studying to become teachers. That is, the income of teachers is not sufficient given the housing choices that we have here in Colorado right now. They're just too unaffordable and too out of reach for people like me and people like my children who are studying to become teachers. So I just keep trying to go back to the why. I and the other bill sponsors are not trying to prevent people from getting their problems fixed. That's not what we're trying to do. But we are trying to carve out a reasonable pathway to get those things done. So just wanted to say thank you so much for the opportunity to be here today, and to all of your guests. I think that everybody that has been speaking today are very passionate and smart people, and I really appreciated their participation.
Thank you, Senator. Appreciate it. Good luck today, ma'am. Jeff, I want to go to you because earlier you and Peter Uckley, I think, agree on something, which is that if you can find a way, I mean, ultimately what we want ideally is that no construction defects right from the get-go, right? Which means that the building is correct. which means that we have developed the workforce to actually do the work correctly to begin with. But what are some of the solutions that you think at a macro level we should be exploring?
Well, yeah, so the solutions discussed in my paper at the very end here included subsidies, or solutions around subsidies, taxes, and zoning. And there's been some debate in the chat over how this would work, but and it varies at the municipal level, but in the city of Boulder, 25% of the units have to be for sale units, and builders can pay cash in lieu. And what the city government does if they pay cash in lieu is they buy apartments and they convert them into for sale condominiums. So it's just a direct solution to the problem, rather than, as I said earlier, trying to tweak construction defect laws, hoping it might lower the cost of insurance, which we don't have any empirical data that it would, or even if it does, there's no reason to believe that the builders are gonna all of a sudden build for sale units rather than all these for rent units.
Got it. Peter, from your answer.
Yeah. Just curious, Jeff. I've read the Boulder language there, and I'm not aware that a rental project would then be required to produce for sale units as part of the inclusionary zoning regulation. It's if you produce rental product, then a percentage of that rental product has to be affordable as rental, or you fee in lieu. Or if you produce for sale product, then a percentage of that for sale product needs to be affordable for sale. But again, we're not building condos. And so all of this inclusionary activity is being directed towards the promulgation of additional rental units. And I'd like to maybe follow up with you on that afterwards, make sure I'm not reading it incorrectly. Yeah, I would say too, and there's been some dynamics, right? Inclusionary zoning is misdiagnosed root cause dynamics. It treats housing as a negative externality. When you treat something as a negative externality, you tax it. Taxation raises the cost of that asset. Now, I am a big fan of providing subsidies directly. Obviously, Proposition 123 comes to mind. I think the federal government needs to be doing a lot more, but the recommendations that I made, in addition to my extensive work on zoning and building code reforms, I also believe that we should be exploring a statewide warranty standard. And this is something that Jennifer mentioned earlier. We want to raise the bar of building quality consistently. And now I believe that our builders are producing high quality products. If you manage and administer any type of multifamily asset, including your own single family home, let's say you have capital needs. Generally, it's about 1% of the overall value of your asset annually, right? So, the homes are living, breathing assets. They expand, they contract, especially as Jennifer mentioned, in our state with extreme climate fluctuations in temperature. But I think if we have a statewide warranty standard, it's something that, could drive us into the future when it comes to the types of resilient, climate-friendly assets that we require and would desire. Secondly, I'd say, as I mentioned, I think that the Middle Income Housing Authority and our great nonprofits like Habitat and Elevation Community Land Trust are primed and ready to step into this space once the litigation environment allows them to not have to eat their shirt and be concerned that they're going to have to put their employees through the gauntlet and then have to deal with outlays of cash many years later. And so this has a big impact, as well as the remaining folks, brave souls, that are delivering for sale affordable product. And then I'd also say that obviously a right to remedy, right to cure that is contemplated in the bill is vitally important. And I think if we do those things concurrently, right, we have to allow more land where we can create gentle density, where we can drive high quality construction, and we need to do it consistently. And the problem is that we're all over the map. One year, the media is saying, right, that we're in a building boom, we need to slow down. The next year, they're saying we don't have enough units. And when actually we start to see some price parity, we're punished for it, and local officials are punished for it. And it's happening now in Colorado. Hey, you built too many units. We're uncomfortable. We're going to recall you. We're going to litigate you. What we have to come back to saying is that as Americans, as Coloradans, our most important asset is our home, right? It allows us to pursue that which is bestowed in us in the Bill of Rights, to pursue happiness. And as we mentioned, the American Dream. Luigi, you mentioned you're an immigrant. I'm a second generation American. I know exactly what you're talking about. The safety and security of a home. We might love Vienna and want to see us have, the renter to ownership flip. That's not going to happen anytime soon. We need to invest in housing stability. The way to do that is through housing abundance. This is not a market versus affordable. We need to be able to create, and we need to build annually. And I'll end there and say, look, one of the things we haven't discussed is that building cycles are generally 2 to 4 years, and affordable, it's 3 to 5 years. Sadara was implemented in 2001. 2007, we had an additional major update to the regulations. If you can look, and this is something I'd love to see us do and other researchers do, is we're just talking about the recession. We're not talking about the compounding impact of litigation as we moved through development cycles, starting with the legislation in 2001, impacted in 2007, many other dynamics. And so the compounding impact of those settlements and jury trial outcomes are what we are saying is the empirical evidence in reference to what's driving those insurance cost spread differentiations. And so those things together, I believe, can make a difference. Thanks,
Thank you.
Luigi.
We have just a few minutes. I do want to ask some of the questions that our audience have raised. I think this is a question for you, Scott. Just really quickly, what's stopping builders from simply building homes per code right now?
Trust me, they do the best they can, and I think Peter brought up a good point. It's imperfect science, right? Everybody thinks you can just go out and do it, and it's difficult to find the workforce. It's difficult to find the workers, and you're dealing on one of these projects. You're going to have 200 people working on a job, each one doing their own respective thing. Everybody's doing their best. They really are. And I think one of the things I've seen is that from 2005 to today, the kinds of defects we're seeing are less severe. At the end of the aughts, I was seeing bearing beams that weren't even on bearing foundation walls. And now it's far more minor defects. So I think we're seeing improvements in quality. This isn't a situation where anybody's saying, look, there should be a get out of jail free card for not performing code compliant work. The existing statute, if it causes damage, if it causes injury, if it causes loss of property, if it creates risk to health or safety, those are legitimate causes of action that exist, and we're not trying to take them away. I think the issue is when you go to a jury and you say code violation, jury automatically thinks it's like a trump card. Jury automatically thinks defect. And the example I gave about the OSB, it's not. It's not uniform noncompliance. It's sporadic noncompliance. The roof's not coming off. It's never going to get fixed, and it's never going to cause a problem.
Thank you, Scott.
That's what we're trying to take out.
Thank you. Appreciate it. Jen, I think this might be a question for you. How do we best help younger generation buyers get into the market?
I think at the end of the day, it's about building homes right. If mistakes are caught at the outset, if homeowners can, if builders work with homeowners to actually properly fix problems when they arise, more safeguards in the law ensuring quality construction, things that prevent defects and prevent the need for litigation. Homeowners, there's a gentleman, his name's John Harris. He's very active in Build Our Homes Right. And he lives in an affordable housing community in 5 Points in Denver. They had serious defects because of the way current law is. They couldn't bring claims against all the responsible parties. We don't have time to get into all the details, but they couldn't sue the developer. They had to pursue claims against other parties. They couldn't recover everything to get things fixed. And these are, a prime location in Denver where there's affordable housing, it's serving a need, but it was built so poorly. They couldn't obtain full relief under the law. They couldn't get the builder to fix the problems. None of that would be necessary if things were done right in the first instance. So I think that's really where efforts should focus, not trying to prevent the number of claims without a lot of focus on what those claims are. And then preventing legitimate claims and shifting the burden onto homeowners who really can't afford to fix the builder's mistakes and shouldn't have to.
Thank you. We're pretty much out of time, but I do want to give Jeff any last comments before we go.
Yeah, I think I've mostly kind of said my piece. One thing just to reiterate is I think we need more data. We're hearing a lot of anecdotal information about insurance rates, court claim rates, and other anecdotal data about what's going on in other states. And what we need, and I know there's a bill in this session to provide this, is more empirical data about insurance rates and court rates to analyze this issue. And just my final point is that this issue is happening all across the country, in every state in the country where they're not getting for sale condos built. That's what the data shows. And there's really no reason to think that the cause of that is construction defect litigation.
Thank you. And with that, Scott, I want to thank you for your time. Really appreciate you, spending an hour with us. Peter, the same to you, sir. Jen, thank you again for your time. And Jeff, of course, thank you. And Vince, thank you for getting those questions. And to our audience, viewers and listeners, thank you for spending the morning with us. Hey, enjoy the rest of your day, and I'll see you soon. Okay?
Thanks, Luigi.
Thank you.
Thanks for a good discussion, guys.
Likewise.
Thank you.